All right, so I'd like to welcome everyone to the first episode of 233 Street Laws Election Petitions Special. We're covering everything regarding the election petitions, those that have been filed in the High Courts, the parliamentary election petitions, as well as that in the apex courts, the presidential election petition that is currently pending. I have on this episode my contributors. And so we have Yawuswa, he's a member of the 233 Street Law crew. I also have
Hello,
Mr. Ebo Asredu. He's a law student at Wisconsin. And I have my brother, Kweku Atakra-Jumo. Kweku Atakra-Jumo, he's a legal practitioner. And myself, Jeffrey Osei-Mensah. And so in today's episode, we're going to be first touching on the Supreme Court's jurisdiction in the first place. Why do we find ourselves in the Supreme Court for this presidential election petition? And after that, we will be looking at the substance of the cases filed by the parties. And so we're looking at John Mahama, we're looking at the Electoral Commission's response. We're also looking at the response from the legal team of Nana Addo Akufo-Addo. And so we'll get to it. First and foremost, what's the jurisdiction of the Supreme Court? I'll direct this question at Atakra. Why do we find ourselves in the Supreme Court? Is there a legal basis? Why not the district court? Why not the high court? Why not the circuit court? Take it away.
Okay, thank you very much for this opportunity. Thank you very much for having me here. So just going straight to the question at hand. Why not the district court? If I'm to answer it from a non-legal point of view, we're talking about the presidential election, challenging the validity of an election that has been held, of which the president, the first person on the land, is involved. So it makes sense to say that the highest court of the land should hear it, and rightly so. The Constitution provides that. Now, that's as opposed to a parliamentary election where the High Court is given original jurisdiction to hear the matter, because we are talking about members of parliament. But here with the president, the Constitution provides that where anybody seeks to challenge a presidential election, the first point of call will be to go to the Supreme Court, to invoke the original jurisdiction of the Supreme Court to hear the matter. So it's a constitutional mandate placed on anybody who wants to challenge any presidential election. So both ways, if you think about it out of the law, even with just logic, it makes sense to say that the Supreme Court should be the one to hear it. But the jurisdiction of court is always conferred by statute, and the Constitution confers that jurisdiction on the Supreme Court to hear any matter where a person seeks to challenge the validity of a presidential election.
Okay. So law aside, in other words, are you saying that the president is more important than the members of parliament? And so for them, they have to go to the High Court whilst the president goes to the Supreme Court?
Well, if you want to say it that way, I wouldn't disagree with you. Because remember that, and for me, always my favorite constitutional provision is that all are equal before the law. Then they'll tell you that the interpretation of that is that among equals, there must be equality. To show that even though all of us are equal before the law, there are some who are more equal than others. Notwithstanding the fact that he's a member of parliament, the president is obviously higher. So
John Mahama is rightfully in the Supreme Court to challenge the elections. All right. So that is out of the way now. We move to the substance of the cases. I'm sure we've all come across the various documents that have been filed by the parties, okay? This election petition was commenced by the filing of a document in the Supreme Court called the petition. And that was done by John Mahama. I believe it was on the 30th of December last year, 2020. And of course, the people against who the petition is being filed, that's the Electoral Commission, as well as Nana Addo Akufo-Addo, would have an opportunity to respond by way of an answer. Now, what exactly are they saying? Okay, we want to zero in on the substance. Take aside the big English and all of that. Abebio, you've perused the petition, you've looked at it. What exactly is John Mahama asking the court to do for him? And what's the basis on which he's asking the court to do that for him?
Okay, so most importantly, I think it's on the relief. In a nutshell, he wants a rerun. He wants the election to be conducted again with himself and second respondents. That's Nana Akufo-Addo, for us to go to the polls and vote again, because in his view, or he submits that at the election held on 7th December 2020, none of the parties, neither him nor the second respondent, were able to satisfy the standard of 50% plus one vote to be able to annex the presidency.
And I
so
gather,
that's in a nutshell. Yeah.
All right. And I gather that's one of the many reasons why he's asking the Supreme Court to do this for him is because I do recall that when the chairperson of the Electoral Commission was declaring the results, she did mention that at that material time, the results of Techiman South hadn't yet come in because the results were being contested. But she did mention that even if they were to add the votes of Techiman South to that of John Mahama, it still wouldn't change the outcome of the second respondent, that's Nana Addo Akufo-Addo, being declared winner. But I gather that one of the reasons for John Mahama requesting this from the Supreme Court is that he says if you are to add the total votes of Techiman South, you are to add it to his votes. It simply means that Nana Addo Akufo-Addo's 51 point something percent that had been announced or declared would be watered down to 49%, 49 point something percent, and his would be increased to 47%. What's your take on this? Do you think it's I don't want to say valid, but do you think it carries water? Ebo?
Okay, that's stable.
I found that argument to be a little strange, if I'm being honest. And but there's a reason why Mr. Mahama has that argument. He's arguing from the position that the mathematics the EC used is flawed. So because it's flawed, they cannot disregard the election results of Techiman.
Okay.
But according to the EC2, if the entire election count was even given to Mr. Mahama, it will not affect the results. Mr. Akufo-Addo will still get the 50 plus 1 needed. So it all boils down to that mistake that the EC chair, according to them, inadvertently made in giving a different number. Yeah, so it all boils down to that conversation.
I think inadvertently too, I may have also delved into the case of the EC. You might have already sparked up a discussion on it. But back to the petitioner's case, all right? In addition to the fact that if they are to add the total of Techiman South's votes to water down the percentages and all of that, there's also this issue about the total ballots cast and total valid ballots, all right? At Accra, Abebio, I don't know if you want to shed a bit more light on that. The fact that at some point, the EC made some wrong reference to a figure as total valid ballots, total ballots cast. There was this back and forth. What exactly is the issue there?
So
I'll have a review take it first. Yeah.
Okay, well, I'll be brief with that. The petitioner claims that the EC in the declaration mentioned total votes cast, which is about 13,434,000. And in their view, I mean, that's like the premise of where the whole contention comes from. That if you add up the total number of votes that the second respondent, that's Mr. Akufo-Addo, and the petitioner, Mr. Mahama, got in relation to this figure, you'd be getting a percentage of one. You'd get a total number of votes of about 13,121,000,
Okay.
So there's a disparity there. That's first and foremost. So from there, that's where they set out a lot more of their arguments.
Okay. Atakra, did you want to add something? Or in essence, that is it from the petitioners?
Yeah, from the petitioner side, I think that's fairly. What I'll say will be on the other side. So
All
I think
right. So let's quickly zoom into the Electoral Commission's response. Okay. What exactly?
I think we get the remaining reliefs from
Yes.
The petitioner side are that, as we mentioned in a nutshell, they want a rerun, but consequence or surrounding that point is that they want the declaration declared as null and void. They want the gazetting of it in CI 135 to be annulled, and that. Yes, in a nutshell, it's all in support of the fact that.
But the issue now is that if you want the Supreme Court to actually annul the results that were declared, where lies the basis on which you request a rerun? Because I believe the rerun is based on the fact that, look, none of us attained the 50%
yes
plus one. All right, and so we've got to annul those votes. Okay, it may mean, look, we're starting from scratch, where we are having all candidates going, we're starting the elections afresh, more or less, because you are saying that, look, let's annul the results as they are now, or you don't.
No, it's annulling the declaration.
The declaration.
The declaration of Mr. Akufo-Addo as president.
But maintaining
in their petition, they proposed that no one acquired the 50 plus one. So they gave about 49.625 and then 46.768.
Okay.
Yes. So based on that, nobody attains 50%. So from there, you are declaring that they want the Supreme Court to declare that none of the parties attain that. Any declaration which is pursuant to that error should be declared null and void. Yes.
All right. So
that
in essence, he's not asking the Supreme Court to declare him as the winner or the president. He's saying, look, let's do a rerun.
No, yes. So contrary to what was in the media before the petition was actually filed, this is what the petition in fact says.
Okay.
No party.
So let's switch. Ebo.
If I could add something small. He's in essence not contesting the validity of the elections. He's more or less contesting the mathematics. And in the answers by the second respondent, he alluded to this, but we are not yet there. So that's the point. He's not saying the election isn't valid. He's saying the EC's maths is wrong.
Okay. So it's a computational issue. So let's switch to the Electoral Commission.
I mean, I don't know if Ibo was concluding, but that is a matter which is in contention. I mean, we'll get to that.
Precisely. I mean, when it comes to the second, I believe the second respondent answer.
The first and the second.
Both of them, yes. So let's switch to the Electoral Commission. What were they saying?
Before we get to the Electoral Commission, just to mention one thing. I found it quite interesting looking at the reliefs of the petitioner, right? Now, one of the reliefs, which was very interesting for me, was the fact that you're seeking for an injunction against the second respondent, that's the president, from holding himself as president-elect. Now, Now, this petition was filed on the 30th, and I think the president had, 10 days from then to respond, of which 10 days will probably bring him to about 9th January.
By which time?
And the Constitution allows that, notwithstanding the fact that there's an election petition, we still have to swear him in, as in the president. So then I found that relief very interesting, because by the time the court gets to hear the matter, that relief would have been rendered unimportant. Because then by then it would have been overtaken by events. So then, as it stands now, that particular relief will be deemed to have been abandoned, because then the court can go back in time.
It's hanging more or less, because he's basically as president.
But I have a question.
Yes.
So can it be said that he's asking the court to still place that injunction on the president, even when he becomes, or when he gets, when he was sworn into power?
That's not possible. That's not possible, because The Constitution allows that, notwithstanding the fact that there's a presidential election petition, whoever was declared as the winner must be sworn in. Yeah. So it will be,
But
the court's decision will be ultra vires to say it's going to injunct him from becoming president.
Right there. So by ultra vires, Atakra simply means that it will be unconstitutional or be beyond the powers of the courts to do
beyond
so.
the powers of the court. Yes, to give such an order.
Yeah, but with respect to Atakra's point that it may be unimportant, I was looking at it from the fact that it's what if it's a prospective relief, that it is if the court agrees with his side of line of argument, or if the court grants him all the reliefs he wants.
Yeah,
it's something that is a relief that you are looking at. So if you are holding the declaration to be null and void, from the point where it is held as null and void to the point where there's a rerun and then there's a new election, between those 2 points, the president at the moment would not be able to, or the second respondent would not be able to hold himself as president within that time.
But let's look at something, all right, Atakra, before you come in. I recall that it was in 2008, there was a runoff, okay? There was a runoff. During that period, or let's take elections in general, okay? During the period from 7th January, when ballots are cast, to let's say 9th January in this case, where the declaration was made, who then is president? Because until you hand over, until you have that swearing in ceremony, which we witnessed on 7th January, okay, a president is in power.
Yeah.
All right. Be he the incumbent, or there is a president in power. And so should the Supreme Court conclude that, okay, John Mahama, we agree with you, these results were erroneous and it attacks the materiality of the declarations that were made, I don't see how the Supreme Court can injunct Nana Akufo-Addo from holding himself out as president.
Yeah,
until
that would be interesting.
The runoff is carried
because,
out.
Yes, that's true. Because if you take the 2008 instance, right, now elections are conducted on the 7th. By the 9th or 10th, we'll know whether we are going for a runoff or not.
Okay.
Now, they always make sure to conduct the runoff even before the end of the year, because whoever is president will sit on the throne until midnight of 7th January, right? So they often conduct the election, let's say around 27, 28. So latest by 3rd January, we know who the new president is. Now, in this particular instance, it's going to be interesting because now, assuming the Supreme Court takes the side of the petitioners.
Yeah.
And now the Supreme Court is saying that we are going.
Atakra. All right. A few technical hitches here. Atakra, I'm sure he'll reconnect and join us again, and we'll continue from where he left off. But for those of us who are here, Ebo, Abebio, myself, let's zoom to the case of the Electoral Commission, okay? What exactly are they saying? Because from the start of theirs, I know they set out the various stages for the collation, the various forms that are filled, those who participate in the filling of those forms, where signatures are signed and all of that. But in direct response to the petitioner's case, as far as the Techiman South results are concerned, as far as the figure, total valid ballots cast are concerned, I mean, those points that they raised, what was their response to the petitioner?
So,
Abebio, go ahead.
Yeah, thank you. So with the Electoral Commission, that's first respondents, they say that they were fair, they were candid, they weren't biased against any party, whether the petitioner or the second respondent. So they are saying that the petitioner is in error. He's dwelling too much on that inadvertent proclamation or declaration on the 9th that the EC chair made. So, and that they corrected it, which was on 10th of December.
With this correction, you mean the reference to the total ballots cast and valid ballots?
Yes.
Okay.
Yes. So that's their main points, that okay, we admit that we made a mistake, but even that, it doesn't materially affect the results, because as you mentioned, all these forms that they set out in explaining the procedure, when you look at the figures on the form 13, which is the final form that the presiding officer for presidential elections fills, it shows that the second respondent did win the election. So yes, so that's in respect with respect to the total number of votes and valid votes.
And also the fact that the petitioners had a copy of that form 13, and so even if what the EC, the EC was announcing had that error, I mean, they were privy to the figures by virtue of the form 13 that they had in their possession.
Yeah, so it's going on the point that they conducted the elections according to the law. They followed all the procedure, gave the opportunity for the candidates or the candidates' agents to peruse these forms or to give reasons why they wouldn't sign whichever form if they wanted to, and all that, all the way up to the declaration stage. So they are saying that they can't base the whole petition on the fact that there was an error when the declaration was made, when in their view they adhered to all the rules that are in the law that they are obliged to adhere to.
So in other words, EC is saying if you want to, the strength of your petition really should be attacking form 13 and pointing out errors that are on form 13. But if there are no errors on form 13, then you can't rely on the mere verbal declaration, which had some error, to mount your petition.
Yeah, form 13 or anything which builds up to form 13, to the final fruit of form 13. Yeah.
Atakra,
and they admit.
I'll give you time to quickly wrap up on the point you're making on the petitioner's case. But Abebio, just land and then let's progress.
Oh, well, I think I'd be going further into the EC's case, even though I'd be brief. But
all right.
So they do admit that the Techiman South elections, where the results hadn't been declared at the point where they were making the declaration, but they again say that when those election results were declared, it didn't. It was about 52,000 in favor of the petitioner and about 46,000 in favor of the second respondent. So even that assumption that they had made earlier, that if you add all the votes, about 120,000 votes from Techiman to the petitioner, it wouldn't materially affect the election. Yeah, so that's they in their view settled that point that the Techiman South elections do not make any material difference in whatever results that they finally declared.
And also the fact that at the time that the petition was being filed, they knew the results from Techiman South. And so to make that assumption, I mean, for me, I found it very interesting because you can't really argue that everybody in that constituency will vote for a particular candidate. I mean, yes, nothing is impossible under this.
I mean, it's an interesting argument, but yeah.
Anyway, so Atakra, just quickly wrap up on the point you are making regarding, when a runoff is held and the gap between the holding of elections to the swearing in. Who is president during that period?
Yeah, so I was saying that, so ordinarily, when elections are conducted by the 7th, by the 9th, we'll probably know who the president-elect is. Now, and that's because the person attained a 50+1 constitutional requirement in an election.
Yeah.
Now, if a person does not obtain 50+1, like we had in 2008, where then President, John Evans, Achabels, and Nana Dankwa, none of them obtained a 50+1, we had a runoff. Now, the runoff, they calculate in such a way that we have it even, I think they often have it just within a week.
Yeah.
Right? They conduct the elections.
And then...
Exactly. So that if you take sides, especially the smaller party, they have to align themselves with any of the party.
Yeah.
They make sure that by the time the results are released for the runoff, the certain president then wouldn't have left. So we'll probably get the results, let's say by the 30th of December, or even by the 2nd or 3rd of January. because the sitting president's mandate ends at midnight of 7th January, right? So then by then he can validly hand over to whoever won the runoff. Now, what makes this particular elections interesting is that now if the Supreme Court takes the side of the petitioners that we are going to order for a rerun. Now then the question is, who then is going to be president? Because that means that Nana Addo Dankwa Akufo-Addo ought not to have been a president. He didn't attain the 50+1 as the petitioners are saying. So is that going to mean that the court is going to injunct him from being president? Now that will be an interesting point, because I would think the Supreme Court won't do that, because at every point in time we must have a certain precedent. Somebody say that, okay, we can injunct he and the vice president so that the speaker is sworn in as president. But that would be a novel case. I don't know how the Supreme Court is going to decide.
This is interesting, but I mean, aside all this, there's also that provision in the Constitution that says, in spite of a presidential challenge, okay, go ahead and swear in whoever has been declared as president. Okay,
exactly. So it means that he was validly sworn in as president. So to injunct him would be interesting. So then that would mean that you probably sit on as the president, quote unquote, for the rerun to be had.
Caretaker president.
Exactly. Now, I mean, just for the sake of advancements of the law, I'd have loved to see how that will play out. Because I don't know exactly. But I still maintain that the relief of the petitioners seeking to injunct the president, Nana Addo Dankwa, the second respondent, as president-elect, I think it has been abandoned. Because remember that the rules of injunction are quite strict to that extent. Now they are claiming a specific relief that let's injunct him as president-elect. And rightfully so, the Supreme Court would have had the jurisdiction to do that. But then when it goes beyond that, and you're saying that now let's metamorphose that to look like, okay, now we are injuncting the president himself. I think that will be problematic. So for me, per my understanding and per my position on the petition, I think that relief is automatically deemed to have been abandoned. Right?
The lawyer is saying a lot of stuff. I was just looking at the expressions on Abebio's face. The lawyer is saying a lot of heavy stuff. But in essence, I think it's just to address the points we're trying to make. That, I mean, among the things that the petitioner is requesting, they want the Supreme Court to prevent, as it were, Nana Addo Dankwa Akufo-Addo from acting as president. And we're just saying that, so within that period of time, who then will be the president? All right. And Atakwa is just trying to give some possible scenarios, but we'll save that discussion for another episode. Ebo, you already started the discussion on the second respondent's case in their answer. Okay. The fact that they were arguing that the petitioner isn't really attacking the validity of the election. He's merely attacking the declaration. And so it becomes a computational issue. Let's go a bit deeper into that. What exactly is the basis on which they are saying this? That Nana Addo Dankwa Akufo-Addo's legal team is arguing this way.
Yeah, so the answer of the second respondent, Mr. Akufo-Addo, is similar to that of the EC, but where the EC took the liberty of explaining the entire election process as provided in CI 127. They took a different approach, and as I said, they kept on reminding the court, as it were, that the petition is not even against the validity of the votes. It's just about the declaration, and they recognize that, yes, the EC chair in her declaration made that mistake that they describe as inadvertent, but it doesn't change the material facts, and then they go on to call most of what was provided in the petition as allegations that are not based in facts. They are conjectured and all that. Basically, that the petition is lying. And then they gave a notice of their intention to raise some objection to the petition. And their first objection was strange for me, because they said that that the petition does not meet the requirements imposed under Article 64(1) of the Constitution. And 64(1) basically says that the validity of a presidential election may be challenged by only a citizen of Ghana and Mr. Mahama, unless they have discovered some strange new evidence, is a citizen of Ghana, as we all know. So I found that ground to be strange.
Hold that thought. I think Atakra wants to address. Atakra, would you want to comment on that? Atakra, can you hear me?
Yeah. Yes, I'm here.
Yeah. Would you want to comment on that? Because I don't know. My understanding is that they weren't really attacking the nationality of the petitioner, but the issue of the validity.
Who is coming? Yes, because if I understand the petitioner on that particular one, what they are trying to say is that under the Constitution, if somebody wants to challenge a presidential election, you should challenge it on grounds of the validity of the elections conducted. To say that there's probably a fundamental error, or let's say there's a big problem in law concerning the elections that may be held. Now, the petitioners are saying that from all that, what the second respondent, that's Nana Dango and legal team, what they are trying to say is that all that the petitioner has said, they haven't spoken anything to the validity of the elections. And so for them, they feel like, since you haven't said anything to the validity, you haven't said that, let's say the ECD have the power to do A, or the ECD have the power to do B, or the ECD have the power to do C. For them, since you haven't said any of these things, then you haven't met the requirement under Article 64. And so if you haven't met the requirement under 64, then it means that your petition is misconceived, or it's not a starter. So it doesn't mean starter.
So by validity, is it that they wanted them to probably allege issues like overvoting, issues like vote padding? Because I take my mind to 2013, Ebo. 2013, where there were issues of irregularities on the face of pink sheets and all of that, where they said, look, the number of people that casted their votes, it didn't tally with the number that was recorded on pink sheet and all of that. Maybe that's what they mean, Ebo.
Yeah, exactly.
Yeah, but in the petition, the petitioner, he alluded to how did he even describe it?
Padding.
Vote padding.
Vote padding.
Yes.
He alluded to vote padding. But so in the response of the second respondent, he's saying that part of the petition talking about the vote padding is not even based on facts. That is conjectured. Yeah, and so in his the objections at the end, he said something I found. Yeah, he called the petition incompetent, frivolous, and vexatious. And that is basically big English, all pointing to the fact that the petition is not valid because one, it doesn't speak to the validity of the election. Two, there's no real facts inside, and it's all just basically lies. And so that's in a nutshell the answer of Mr. Akufo-Addo to the petition.
Abebio, any comments on the position of Nana Akufo-Addo and his legal team?
Well, no, maybe I would send you back to the EC. One important point is where they admit the possibility of minor mathematical errors or computational errors, despite the training and education they give to their officials and those of the candidates and other people who are involved. But they claim that these errors do not materially affect
the outcome of the declaration.
Results that were declared. Yes. Okay. That's just something I wanted to point out, but that's for the EC and the first respondent.
Okay. And there's this mention of preliminary objections here and there. I know presently a preliminary objection has been filed, but just for the education of members of who may not appreciate some of these legal terminologies. Ataka, quick one. When we say preliminary legal objection, basically in layman's English, what exactly are they saying?
Okay, so with a preliminary legal objection works this way. So somebody has sent his case to court saying that I want the court to hear A, B, C, D, and for the court to do E, F, G. Now, the person has used the action against me. even before I decide I'm going to answer what the person is saying, I'm trying to tell the court, don't waste my time at all and waste your time to hear what I have to say. What he has presented for you, it doesn't even, it's not worth the court's time. So let's throw it away. And that's what we call the preliminary legal objection. So before I even respond, before you allow me to say anything, let's throw out his case. So hear what I have to say to throw out his case. And if we all know how the court works, so I mean, it's not just any matter you can send to court actually. The court has some specified matters depending on the law that it can hear. So let's say that if somebody, just like the example you gave, that why should we start the election petition but and not the district court? Now, as I explained earlier, the Supreme Court is the court that has the power to hear a matter concerning a presidential election petition. Now, assuming the petitioners have started in the district court, now that's a non-starter because they are the wrong place. So then, in that regard, the respondents won't even have to file the answer. They'll file a preliminary legal objection to say that the court does not have the power, the district court does not have the power to hear hear this particular matter because in the wrong.
So in essence, they are saying the case is dead on arrival.
If the second respondent tries some requirements, right? They are saying that the petitioner hasn't met some requirement that should even make the Supreme Court hear the matter at all. So that we don't waste anybody's time, we are raising a preliminary legal objection. So at the Supreme Court, when he hears it and he agrees to the second respondent, to end the matter at that point.
Okay. I think it's been a great discussion. We've been able to touch on the substance of all the parties' cases. We wait to see what the Supreme Court will say, especially about this preliminary legal objection, which in subsequent episodes we'll go into and try and appreciate exactly the grounds on which these objections are being brought. Atakra, I don't know if you had a final thought you wanted to share.
Yes, just to add to what Ibu was saying on the president's answer.
Yeah. So
I also find it quite interesting. Now, let me start from the preliminary legal objection they raised. Now, after they are saying that under Article 64, you haven't instituted your action properly because you are not challenging the validity of the election. After they say all the big English Ibu was trying to explain to us, they come back to say that even if all that the petitioner, that's John Mahama, is saying is true, that there's been some irregularities, even if it's true, they're saying that vote pardon, if they add up everything, it's just about 5,000 votes. And they're saying that the president's winning, that's President Akufo-Addo, he won by over 500,000 votes. So even if we decide that vote party they are saying is true, we take out that just 5,000 from the 500,000, nothing will change. So then they support back to what they are saying as their first objection, that you haven't attacked the validity of the election. Because even if we agree with you that all you are saying is true, it's just 5,000. We'll take out that 5,000. What, 5,000 out of 500,000? What, 495,000? And even he had more than 500,000. They're saying that, in fact, you are saying nothing. So let the preliminary legal objection stand and let you strike out. Now, another interesting point they make also, just the last point, please.
Yeah, sure.
Another interesting point they make is that they're like, okay, so the petitioner, you're saying that we should have a rerun. Nobody has made a 50+1. But one thing the second respondent is saying that you petitioner, you haven't shown to us that how much did you get or how many votes did you make. You haven't told us. Now we are saying, we are depending on what the Electoral Commission said, you got so much. Now you are disputing it.
So if you bring your own,
we tell us, okay, pay your accountant. Exactly. Pay your accountant, what did you get? If let's say pay your accountant, you say, oh, I got, let's say 12 million or 10 million. Then now when we do the calculation from your side, you can tell, okay, pay the figures you brought, pay the figures you say the second respondent and Addo also got. If we add everything, we see that, okay, you both got 49. Then we can agree to the runoff. But you haven't told us anything. So then how do we agree with you? So based on that, the second respondent is saying again that as a preliminary legal objection, let's check out their case. They are not saying anything. They are just conjecturing as they've explained to us. They are just on the wild goose chase, just trying to say something to waste everybody's time. That's why they're also
all right. Audience, please don't think that Atakra is speaking for Nanado or any other party.
No, I'm not. I'm only just
exactly
explaining
what has been filed in their document, so we all understand. And so we'll conclude on this episode, but I'll just leave you with one question. It flows from this preliminary legal objection. If they are saying that they are not attacking the validity, that's the EC as well as Nanado Dankwa Akufo-Addo is saying that the petitioner is not attacking the validity of the elections, and so shouldn't have even brought this petition to the Supreme Court. They've admitted that there's an error as far as the declaration is concerned. So when it comes to rectifying that error, which court should they go to? That's just a question for us to ponder over. We'll revisit it in our next episode. Ebo, thank you very much. Atakra, thank you very much for joining in. And Abebio, it's been a great discussion. Do well to tune into our next episode. Thank you very much.